Senator, yield for a question.
Yes.
4 years ago, we passed legislation under the Defense Authorization that allows the American government to detain an American citizen without a trial. Think about that. One of our basic rights, one of our most important rights is the right to a trial, to be represented, to have a jury of our peers. And you say, oh, well, it'll never be used. Well, President Obama recognized this. He said, this is a terrible power, and I promise never to use it. Any president who says a power is so terrible he's not going to use it should not be on the books. As the senator from Utah said, it's not about having laws that require angels to be in charge of your government. Someday there will be someone in charge of the government who makes a grievous mistake, like rounding up the Japanese. So we have to be very, very careful about giving power to our government. That's what the challenge is here. Many will say, well, we are at war, and at war you have to have the law of war. What is the law of war? Also known as martial law. But this is a war that does not seem to have an end. They're not asking you for a 1 or 2 year period in which there won't be trials. They're asking you to relinquish your right to trial for a war that may have no end. And I want you to imagine this. Who could these enemy combatants be that may not get trials? Imagine that you're an Arab American living in Dearborn, Michigan, and you send an email to someone overseas. Maybe that person is a bad person. Maybe there is a connection. But should not an Arab American in Dearborn, Michigan have a right to defend themselves in court and say, I was just sending an email to him and I said a few stupid things, but I'm not a terrorist? Shouldn't they get the right to defend themselves? We need to be very careful that as we fight this long war, that we don't wake up one day and say we won the war, but we lost what we stood for. We lost the Bill of Rights. We lost what our soldiers. I know soldiers who have lost 2 arms and a leg fighting for us, and they come back and they say they were fighting for the Bill of Rights. That's what this should be about, protecting the Bill of Rights while they're gone. And so the question I have for my esteemed colleague is, some will say, well, they get a hearing, they get a habeas hearing, they go before a judge. Isn't that due process? Is a habeas hearing equivalent to due process?
No. Now, due process can include habeas, but some might say habeas corpus is the beginning of due process, not the end. Sometimes it occurs at the beginning, sometimes at the end, but regardless of when in the process it occurs, a habeas proceeding does not represent the sum total universe of what due process means. Look, you can't read the 4th, 5th, 6th, and 8th Amendments to the U.S. Constitution to see that what happened in the version of the NDAA that we passed in 2011 was an affront to the constitutional order. It was an aberration. Now, we're not asking for anything drastic. All we are asking here is that before the government take this step, the type of drastic step that you're describing, that at a minimum, that we require Congress to expressly authorize that. Is that really too much? And for those who would say we're at war, we're under danger, and I understand the point. There are those who don't like our way of life. They perhaps want to do us harm. For those who would say that we are at war and we've got to take that into account and we've got to consider that, my response is, okay, if that's the case, then let's at least do it the way we're supposed to do it. Let's at least have that discussion, rather than doing it by subterfuge, rather than doing it under a cloud of uncertainty, rather than doing it by implication. We need to do so expressly, and that's all this amendment does.
And let me clarify in a follow-up question. If an American citizen goes to Syria and fights with ISIS and is captured on the battlefield, this amendment would not mean that they get a trial. No. They still could be held as an enemy combatant.
That's correct. This would not cover that at all, because that person is outside the United States. That person is captured on the battlefield, a battlefield outside the United States. That person wouldn't be covered by this amendment.
And let's just also be clear what we're talking about. People who have been defined as enemy combatants aren't always holding a weapon. You can be a propagandist. For example, we have had propagandists that have been killed overseas who were propagandists for the enemy. So it is conceivable that an American citizen could be exchanging information and say something derogatory about us or something in favor of the enemy, and that could be considered to be that person's now a propagandist. I guess my point is that shouldn't they have a day in court to determine the facts and have representation as opposed to being plucked up and saying, you're going to Guantanamo Bay for the rest of your life because you made some criticism that it's now the state has deemed you an enemy?
Yes, that's absolutely right. And that is precisely why we need these protections. And that helps illustrate the slippery slope nature of this problem. And it also emphasizes why it is that if there are some in our body who want to make sure this power exists in the government, that we must pass legislation affirmatively making it so, expressly providing that power, rather than doing it indirectly. That's all our amendment does. This is indeed a slippery slope. If all you have to do to indefinitely detain someone without charge, without trial, suspending their rights under the 4th, 5th, 6th, and 8th Amendments, if that's all you have to do is charge them in a certain way, then our constitutional protections have become weakened indeed, weakened to a dangerous degree.
And is it currently true that this amendment's being blocked by one senator from gaining a vote?
We're trying to get a vote. This got a vote in 2012. This received 67 votes, votes from people of both parties, votes from some members, including at least one person who you may be thinking of who has objections to it now. And so we need this to get a vote. If we are going to vote on other amendments, which we should be doing, this should get a vote. Nobody has explained to me why this should not, at a minimum, receive the vote. If someone doesn't like this, fine, let them vote against it. But we should have a vote on this because this is very relevant to the National Defense Authorization Act. It was, after all, the National Defense Authorization Act passed in 2011 that was the vehicle for enacting this into law.
And I guess one concluding point I would make would be that we have time in the Senate body to vote about which rockets we're going to use, made in which state and which country. Shouldn't we take time to vote about the abrogation or the possible abrogation of the Bill of Rights, of the right to a trial by jury? I think that this is an eminently important issue, should not be pushed under the rug, and that no one should be afraid to take a stand. Not everyone will agree, but we should be allowed to take a stand on the Senate floor, openly debate, and have a vote on whether or not you will have your right to trial by jury, or whether or not we're going to abbreviate that right and say we are at war. But realize, if you think that your rights can be abbreviated in times of war, that this is a war, that the people who tell you they're going to abbreviate your rights are also telling you that this war has no end, that there is no conceivable end to this war, and that the diminishment of your liberty, the loss of your right to trial by jury, will go on and on without end. I wholeheartedly support my fellow senator from Utah's amendment, and I advocate for having a vote on the Senate floor.
I agree, and I note the presence